As to the verdict, it reads as follows. We, the jury, find as follows: malice murder. We find the defendant guilty. Count 2, felony murder. We find the defendant guilty. And count 19, making a false statement. We find the defendant guilty.
In the spotlight this morning, the Georgia mother who killed her toddler son and dumped him in a landfill wants a new trial. Last year, a jury convicted Leilani Simon on 19 charges, including murder and concealing a death for the murder of little Quinton. She was sentenced to life with the possibility of parole after 40 years. Simon reported Quinton missing in October of 2022, and in the days after begged police to help find him. She even spoke to a local TV station, WTOC.
We're in limbo. We're in limbo just like everybody else is. We're sitting here every day waiting for answers. Being in this house is hard. My mother and I can't even stay inside throughout the day. We always are outside because there's just so many memories that we don't know if we're going to have again.
There's something else, that case. During the trial, the prosecution showed videos of Simon being interviewed by police.
He was alive last time I seen my baby. He was alive and he was moving and he had color in his face and he was my happy baby. I don't know where my baby is. I don't know what happened to him. And all I know is that you're sitting here constantly trying to ask me to help you find him, and I'm doing the best that I can, but nothing that I'm going to tell you is going to change if I'm being honest.
Well, in the motion for a new trial, her attorneys claimed that statements to police were wrongly admitted after the court denied a motion to suppress. They also argued that the court should not have allowed certain evidence about Leilani's alleged sexual relationship with a drug dealer to be brought into the case. That's the basis for the new trial. Will it work? Here to discuss, criminal defense attorneys David Bruno and Joe Tamburino. Joe, your thoughts on success levels here for a new trial for Miss Simon?
No, it's not going to work. This is a very sad case. I mean, she grew up in a very troubled background. The whole thing is very sad. But, basically this. Whenever you get a motion for a new trial that says, look, there wasn't enough evidence to convict the person, it's basically called sufficiency of evidence. Those lose. 99% of the time, they lose. But many times, it's the only thing that the defense can raise to try to do it. And everything else that she says about the statements, invocation of her right to counsel, and so on, that was already litigated. So I just don't see this motion going anywhere.
David, to Joe's point, this was a trial that you just saw that little face of Quinton throughout it, and for jurors, I'm sure they went through it and just had seething reactions towards this mother who not only let down her child, but then tried to ineffectively put on this charade with the media and investigators. First, your thoughts on the chance for a new trial here, and then also just talk about this trial and her, this person as a defendant.
Yeah, sure. Had to look at this too about procedural, why this is being filed. This is Georgia law. In fact, after a conviction, they have to file this motion in the trial court before it goes up on direct appeal. It's before the same presiding judge, the same judge that made the same evidential rulings pre-trial about the statement and as the objections came in and the briefs were filed. So there's really no chance. I don't see anything new here. This is really a procedural step that had to be made before the direct appeal up to the appellate division. When I look at these clips, Ted, I think of the balance between public perception and the constitutional rights to remain silent. You see this mother, which probably thought, like, I had to get out there and I had to give this emotional statement when they're looking for my child. And then you also show the interrogation with the police, obviously waiving her Fifth Amendment rights to remain silent because she probably already opened the bag with the public statement, now felt compelled to give that statement right there with law enforcement. And it really evidenced evidences this conflict that suspects have during these criminal investigations between what they perceive the public needs to see, the public statement, versus the invocation or lack thereof in the interrogations. And she kept on talking, and it was one of the reasons for her demise once they were able to find the victim in the case, and then all of the other evidence about the abuse and the way that she treated this particular child.
Mm-hmm. You can just see those investigators letting her talk as long as you want. Keep going there with your theatrics. Let's listen to the sheriff. You talked about this, Joe, this being an emotional case. It sure was. Even law enforcement was hit by this tragedy because this little soul was lost for no reason. Take a listen.
We feel that we have a very strong case. We have put thousands of hours into this. And we believed that this was the right move today to be able to do that. She doesn't deserve a Thanksgiving, quite frankly, if I can go off script a little bit. Quinton deserves that.
Yeah, Joe, you see the sheriff there getting emotional. It's just such a waste. This little boy loses his life for who knows what ridiculous reason.
Well, that's correct. And that's why whenever you have child abuse or including child death cases, they're always very emotional. Why? Because they involve children. And the thing having a child victim is exactly what you said. It's nonsensical. You know, children are innocent. Why would you kill a 20-month-old, a 3-year-old, a 5-year-old? Also, they have the rest of their lives to look forward to. They come into this world completely pure, and they rely on their caregivers. And so, you know, it's such a betrayal of, you know, just human nature for the caregiver, be it a mother or a father, to just not even care about their own child and kill them. It gets at a person's core. So yes, of course, they're always emotional. They're always extremely difficult to defend.
Yeah, and David, from an appellate standpoint, does it matter the type of crime, or is it all just legal decisions that were either erroneous or not in terms of the mindset of an appellate judge typically?
Yeah, when the appellate court looks at these issues on appeal, it depends on what the reason or the error was. Oftentimes, the appellate courts will find errors, but find them to be harmless errors. So it depends, because not all errors result in reversals. So if it's significant enough, if it's constitutional based, oftentimes it doesn't matter how heinous the crimes are, they are reversed. But when the evidence is overwhelming, when there are other reasons for the convictions, when it doesn't rise to a level of the impact that some others do, it could be found to be harmless, which doesn't actually result in a reversal.
All right, we shall see what happens with that.